Consider the scenario where you have a life insurance policy with a significant death benefit. If your spouse remains the beneficiary, they will receive the payout upon your death, regardless of the state of your relationship. Hello, everyone. Welcome to the Wills, Women, and Wealth podcast. I'm Elsa W. Smith, your Maryland estate planning and probate attorney, and I'm thrilled to have you with us today. We're here to empower women who value their health, wealth, and the legacies they're creating. This podcast delves into a diverse range of subjects encompassing finance, law, mental, and physical health, and beyond. Our commitment is to furnish you with invaluable insights, engaging expert interviews, and enlightening episodes that address your questions on wills, estate planning, and probate matters. Remember, this is your community, and we want to hear from you. Engage with us, ask questions, suggest topics. Let's build a dialogue. Reach out to us on social media or leave us a comment below. Your input fuels the conversations we have. You can find all of our episodes on YouTube, Spotify, and Apple Podcasts. Be sure to subscribe and stay tuned for our upcoming content. We appreciate your support. And if you enjoy the podcast, please consider leaving us a 5-star review. Your review helps amplify our reach and brings our content to more listeners. In today's podcast, we're kicking off a special 2-part series focused on estate planning before and after a divorce. In the first part, we'll explore essential strategies and considerations for estate planning before a divorce. Then, in our second part, we'll dive into the crucial steps you should take to update and secure your estate plan following a divorce. Whether you're currently going through a divorce or planning for the future, this series will provide valuable insights to help you navigate the process with confidence. Let's get started. Review and update beneficiaries. One of the first steps to consider before a divorce is to review and update your beneficiaries. This includes life insurance policies, retirement accounts, and other financial instruments. Often, spouses name each other as beneficiaries on these accounts. If you're contemplating a divorce, it's crucial to ensure that these designations reflect your current intentions. You may want to change beneficiaries from your spouse to another family member, a trusted friend, or a revocable living trust. This helps ensure that in the event of your death, your assets will go to the individuals or entities you choose, rather than to a soon-to-be ex-spouse. Consider the scenario where you have a life insurance policy with a significant death benefit. If your spouse remains the beneficiary, they will receive the payout upon your death, regardless of the state of your relationship. By updating your beneficiary designations, you can redirect those funds to your children, a charitable organization, or a living trust that will manage the money according to your wishes. Are you in Maryland or DC embarking on your estate planning journey? Let us guide you through the process. Join us for a complimentary 15-minute call with a member of our team. There's no obligation. Check out the show notes for the scheduling link. Your first step towards securing your family's future starts here. Pre-Marital Agreements. Next, let's talk about premarital agreements. While they might seem unromantic, prenuptial agreements are practical tools that can simplify the estate planning process and protect your assets in the event of a divorce. A prenup clearly defines asset division and ownership, which can prevent lengthy and costly disputes. It ensures that both parties enter the marriage with a clear understanding of their financial rights and responsibilities. For instance, if you own a business, a prenuptial agreement can stipulate that the business remains your separate property, safeguarding it from division during a divorce. This agreement can also address spousal support and the division of property acquired during the marriage, providing clarity and reducing the potential for conflict. Property ownership. Understanding how your property is titled is another critical aspect of estate planning before a divorce. One form of title commonly used by married couples is tenancy by the entirety, or TBE. Tenancy by the entirety means that the property automatically passes to the surviving spouse upon death. If this is not your intention, consider changing the title. For example, you might want to convert the current form of title into tenancy in common, where each party owns a specific share of the property that can be bequeathed to someone other than the spouse. Imagine you own a home with your spouse in a TBE form of title. In the event of your death, the property would automatically pass to your spouse. If you wish to leave your share of the property to your children or another family member, you would need to change the current ownership structure. By converting to a tenancy in common, for example, you can ensure that your portion of the property is distributed according to your will. Power of attorney. Reviewing and potentially updating your power of attorney designations is essential when planning for a divorce. Power of attorney grants someone the authority to make financial or medical decisions on your behalf. If you do not want your current spouse to have this control, appoint someone else. This is particularly important if the divorce is contentious, as it ensures that your financial and medical decisions are made by a trusted individual. Consider a situation where you become incapacitated and unable to make decisions for yourself. If your spouse holds your power of attorney, they would have control over your financial and medical affairs. By updating your power of attorney, you can appoint a trusted friend, family member, or professional to act in your best interests, ensuring your wishes are respected. Wills and trusts. Updating your will and any existing trust is another crucial step in estate planning before a divorce. Ensure that your current spouse does not inherit assets you no longer wish for them to receive. This is especially important if your relationship has deteriorated. Consider setting up a living trust to protect your assets and provide for your loved ones according to your specific instructions. For example, you might establish a revocable living trust, allowing you to manage and protect your assets during your lifetime and specify how they should be distributed after your death. By doing so, you can ensure that your assets are used to benefit your children, other family members, or charitable organizations, rather than going to an ex-spouse. Guardianship. If you have minor children, determining who would be their guardian in the event of your death is a critical consideration before a divorce. This decision might change if you are going through a divorce. You need to think about who would best care for your children and ensure their well-being. This choice should be reflected in your will, providing clear instructions and avoiding potential legal battles. If you initially named your current spouse as the guardian of your children, you may have to reconsider your choice if you're planning for a divorce. If your relationship has become strained, you might prefer to appoint a trusted family member or friend as the guardian instead. By updating your will, you can ensure that your wishes are known and that your children are cared for by someone you trust. Tax implications. Finally, be aware of potential tax consequences related to asset division. Proper planning can help mitigate unnecessary tax burdens. Divorce can trigger various tax issues, such as capital gains tax on the sale of property or taxes related to retirement account distributions. Consulting with a financial advisor and/or tax professional can help you navigate these complexities and develop strategies to minimize tax liabilities. Your estate planning attorney can be a good resource to help you outsource these responsibilities and connect you with the appropriate professionals. If you and your spouse, for example, decide to sell a jointly owned property, you may be subject to capital gains tax on the sale. By understanding the tax implications and planning accordingly, you can reduce the financial impact and ensure a smoother transition through the divorce process. To review, estate planning before a divorce involves a comprehensive review and update of various legal and financial documents. By considering these key points, that is, reviewing and updating beneficiaries, considering premarital agreements, understanding property ownership, updating your power of attorney designations, revising wills and trusts, determining guardianship for minor children, and being aware of tax implications. By doing these things, you can protect your assets and ensure that your wishes are respected. Proper planning provides peace of mind and ensures that your loved ones are provided for according to your intentions, regardless of the outcome of your marriage. At the law offices of Elsa W. Smith, we focus on empowering women through estate planning. Whether you're preparing for the possibility of a divorce, navigating the changes it brings, or facing the emotional and logistical challenges of fulfilling a loved one's final wishes, we're here to help. I invite you to take the next step towards peace of mind by scheduling a complimentary 15-minute call with a member of our team. We'll listen to your concerns, provide personalized guidance, and outline how we can support you through every phase of estate planning, especially before and after a divorce. Click the link in the show notes or visit our website to book your call today. We're also offering a free downloadable resource on estate planning considerations before a divorce, available on our website at elsadwsmithlaw.com. Thank you for joining us on this episode of the Wills, Women, and Wealth podcast. Be sure to stay tuned for part 2 of our series, where we'll discuss estate planning considerations after a divorce. I'm Elsa W. Smith, your Maryland estate planning and probate attorney. Until next time, stay informed, stay empowered, and take control of your legacy.